Hello and greetings to the viewers of Law and Life. This is Shashank Mishra as a host, present with renowned senior advocate of Supreme Court of India, Subodh Markandeji. In this channel, senior counsel discusses on the current legal issues that are happening in India, statutes and political history of India, and other such related topics. Similarly, in this episode number 44, which is on the topic Supreme Court restates the principle of bar of civil court jurisdiction. So on this topic, my first question is it true that the jurisdiction of civil court is all persuasive and exclusive of civil court jurisdiction must not be easily presumed? It must be exist in the statute by express words or by clear implication. Which are the cases laying down these principles?
So yes, this is because of Section 9 of the Code of Civil Procedure. Uh, it has been interpreted since Section 9 was enacted, but there is a very celebrated case of the Constitution Bench in Dhula Bhai, Dhula Bhai versus State of Madhya Pradesh, reported in AIR 1969 SC, page maybe 79. Civil courts, of course, guard their jurisdiction very jealously and also zealously. In a recent case, Saw Rajni versus Saw Smita, a civil appeal number 5216 of 2022, decided by Supreme Court as recently as 8th of August 2022, this year. These principles have been very succinctly brought out because in the pseudo of the factual situation, they have come out very vividly. Uh, it was in the case involving plea of exclusion of civil court jurisdiction, facts as established on record, the statute providing for exclusion of the bar of civil courts jurisdiction, and the case law bearing on these principles have to be very carefully evaluated and applied. It's a difficult task.
So let's begin with the fact of the case.
Yeah. So here what has happened is that regular civil suit number 775 of 1993, 1993, just imagine, it's getting, after almost 30 years. So the suit was filed before the Civil Judge Junior Division, Amravati, by the appellant, let's call her plaintiff, against defendant number one, Saw Smita, and second defendant is Amravati Area Development Board. So as per the plaintiff averments, plaintiff was the allottee of in possession of block number 4/6 on the first floor, while defendant number one was the allottee in possession of ground floor, block number 4/2. So defendant, according to plaintiff averments, defendant number one made illegal and unauthorized construction of 4 rooms on the open vacant site towards the north and east of the block as depicted in the plan annexed to the plaint. Such illegal construction by defendant number one disturbed the plaintiff's easementary rights to privacy, light, air. So these are the fact situations which ultimately, ended in favor of the plaintiff because the suit was for the enforcement of easementary rights to privacy, light, and air, apart from two or more things. Defendant number one also constructed a staircase gaining access to the terrace, which also disturbed the plaintiff's privacy. Further, defendant number one removed water pipeline affecting the water supply to the plaintiff and also blocked the service line for cleaning the septic tank. The plaintiff raised complaints against such illegal acts of defendant number one with that board, Amravati Area Development Board, which is defendant number two, and also issued notices to both the defendants for removing the illegal construction without any result. Therefore, the plaintiff filed a suit for mandatory decree to the defendants for removing the unauthorized constructions, permanent prohibitory injunction, permanently restraining the defendants from making any constructions, and directions to keep open site as it was, and direction to restore the water supply, and permanent injunction to remove obstruction to service line, and permanent injunction to restrain defendants to encroach or construct on the open site or cause any nuisance. Now, in the first, I think from the record or judgment, it does not appear that defendant number two uh, contested this suit. But first defendant in her written statement pleaded that sections 71 and 177 of the Maharashtra Housing and Area Development Act 1976 barred the jurisdiction of the civil courts to entertain the suit. The trial court held that suit related to legal rights of the plaintiff and not to the powers or business of the society. I think they meant bold. On merits, it held that defendant number one had made illegal constructions, removed the water pipeline, and blocked the access to septic tank, thereby affecting the plaintiff's legal rights, not rights under that act. Therefore, the trial court decreed the suit in toto. The first appellate court concurred with the findings of trial court and dismissed the first appeal of the respondent number one, and consequently declared the suit of the plaintiff. The concurrent judgments of the trial and first appellate courts were assailed in the second appeal by defendant number one under section 100 of the Code of Civil Procedure. The High Court, relying on section 66(1)(4), uh, 71 and 177 of the Maharashtra Housing and Area Development Board Act 1976, held that board had power to evict the allottees if it is satisfied that material alterations had been made without its permission. By sections 77 and 171, jurisdiction of the civil courts is clearly barred in the matters where the competent authority has exclusive jurisdiction. Defendant number one's second appeal was therefore allowed by the High Court, and the concurrent findings of the trial court and the first appellate court were set aside, and the suit was held to be barred and therefore dismissed. Consequently, the plaintiff carried an appeal by special leave under Article 136 of the Constitution to the Supreme Court.
Sir, so what happened in the Supreme Court?
So, there were two sections in the Maharashtra Housing Area Development Act 1976 which barred the civil court's jurisdiction, namely section 77 and 171. There were two sections which barred the. But for determining what fell within the bar of the civil court's jurisdiction, the Supreme Court read section 66, which occurs in part 6 of the Act, and it confers upon the competent authority power to evict if a person authorized to occupy any authority premises, that is board's premises, does not pay rent or compensation or amount lawfully due from him in respect of such premises for more than 2 months, or sublets without previous permission of the authority, in whole or part, or has committed or is committing any act destructive or permanently injurious to such premises, or makes or is making material additions or alterations in such premises without previous permission of the authority. According to section 77, The Supreme Court noticed that bar of jurisdiction under this section applies on the eviction of any person from any authority premises or on recovery of any rent, compensation, amount of damages for use and occupation, or in respect of any order made or to be made, or action taken or to be taken by the competent authority or the appellate authority to grant any injunction in respect of order or action taken by these authorities. As regards Section 177, which also contains another uh, bar of civil court's jurisdiction, the Supreme Court stated that it has enacted a bar in respect of any matter which the authority or tribunal is empowered by or under the Act to determine, and no stay or injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred or duty imposed. Therefore, just see what has happened is although there are two sections which bar the civil court's jurisdiction, the subjects of bar are delineated in these two sections. And the court held that plaintiffs' uh, reliefs, which plaintiff claimed, do not fall within any of these two uh, uh, sections. It's outside the ambit of these two sections. On the Therefore, the plaint proceeds on the basis that both the plaintiff and defendants are lawful occupants of their respective uh, flats or whatever. Uh, what the plaintiff is aggrieved of is the illegal construction of four rooms, thereby obstructing her lawful enjoyment of easementary rights to privacy, light, and air, which do not fall within the purview of this act, and also the removal of pipeline and interference with the drainage. And probably it is not stated in the judgment, but what also probably weighed with the Supreme Court is that defendant number two, did nothing even after bringing to its notice all these things which have been done by the uh, first defendant. So these are matters which are outside the operation of Section 66, on the basis of which the bar of jurisdiction is enacted in those two sections. Therefore, relying on Dhulabhai versus State of Madhya Pradesh, to which I have made reference, Ramesh Govindram versus Sugra Humayun Mirza, reported in 2010 8 SCC 726, and Competent Authority versus David Mantosh, 2020 12 SCC 542, the court held that reliefs claimed by the plaintiff were beyond the scope of Maharashtra House and Area Development Act 1976. Therefore, this is the crucial test. Are the reliefs claimed by the plaintiff within the scope of the act or beyond the scope of whatever act which creates the bar of jurisdiction of civil courts? So the court held that the reliefs claimed by the plaintiff were with regard to the easementary rights to her privacy, air, and light, and also those two things which, that is water supply and drainage, in regard to which defendant number two did not do anything. So resultantly, the appeal of the plaintiff was allowed, and the judgment of the High Court was set aside, and concurrent judgments of trial court and first appellate court were restored. So this is how the Supreme Court decided the controversy. The question is whether the reliefs claimed by the plaintiff fall within the area covered by the bar of jurisdiction.
Yes, sir. So, with the Supreme Court's answer to the questions, we will be ending this session and winding up for today. Again, thank you, sir, for sharing and informing all about it. See you, sir, in the next video, sir. Thank you, sir, for joining.
Thank you, Shashank.